Ladies and gentlemen, welcome to lawcaseuk.com, where today I'm going to be analysing the 2020 Court of Appeal decision in Barton and Booth against the Crown. Or maybe I could rephrase that to say that what I'm actually going to do is I'm going to attempt to examine the test for dishonesty when it's an aspect of mens rea in criminal cases. And I'm going to do this for a couple of reasons. Firstly, because dishonesty is a significant aspect for students studying criminal law, normally in the first year of their degree. And secondly, I'm doing it because there has been a significant change to the law in this area in recent years, and Barton and Booth marks the culmination of that change. And in the particular case, the appellants Barton and Booth are both appealing their convictions on charges that contained dishonesty as an element of the offences. For example, on the indictment, they're charged with theft, they're charged with conspiracy to defraud. And I should say that whilst the judgment tells us something about the other elements that go to make up the offence of conspiracy to defraud, I'm not particularly interested in that aspect for the purpose of this analysis. For this analysis, what I want to do is strip the case back to only two aspects. Now, the first of these, and the main one, is the test for dishonesty in the criminal law, and here the case, as I said before, is representative of this significant change that happens, and it's a change that begins in 2017 with a case of Ivey, which I'll get to in due course. And the second effect of this case that I want to explore, albeit more briefly, is the effect of the decision on the application of the common law of precedent between courts, by which I mean when lower courts are bound to follow the reasoning in a similar case that has been decided by a superior court. But let me start with the main point, the test for dishonesty. Dishonesty is a mens rea element for a number of offences, but most obviously theft. And since the 1982 Court of Appeal decision in the case of Crown against Ghosh, the test for dishonesty was taken to be a two-stage test that involved a court having to consider two things before it could decide that a defendant had been dishonest. Now I'm going to read to you the two limbs of the Ghosh test. The first is that the court or jury would have to decide whether a person was dishonest according to the ordinary standards of reasonable and honest people. So you can see immediately that's an objective test. Would reasonable people think that what the defendant had done was dishonest? And of course, if it wasn't dishonest by those standards, then that's the end of the matter and the prosecution fails. But if it was dishonest by those standards, then the court had to go on to ask a second question, which was, if it's dishonest by those standards, the court has to ask itself whether the defendant, him or herself, must have realised that what he or she was doing was that what they were doing was by those reasonable standards dishonest. So this brings in a subjective element because we're looking at the actual mind of the actual defendant. And both limbs of the test had to be satisfied before a court could conclude that someone had been dishonest. And this test stood for some 25 years until 2017, when the case of Ivey and Genting Casions comes along. Now, the first thing you might notice from that is the title is a title of a civil case. It's not the Crown against anyone. It's two legal personalities, Ivey and Genting Casions. And in this case, there's a civil dispute that needs to be resolved between those two parties. Nobody's been charged with a criminal offence. But in these civil proceedings, the Supreme Court was deciding whether Mr. Ivey had behaved unfairly by using his knowledge of the patterns on the back of playing cards to determine the type of card that was going to come out when gambling in a casino. So he could identify something particular about the patterns on the cards, and that gave him an advantage over the casino. Of course, ordinarily the casino has the odds stacked in their favour, but by this tactic he was able to turn the odds slightly in his favour. And extraordinarily, by using that tactic, over the course of a couple of days, he was able to win some £7.7 million from a particular casino. perhaps unsurprisingly, the casino refused to pay up. And what these civil proceedings are about is Mr. Ivey suing them to recover the money that he says he's owed. The casino says, we don't owe you the money because you cheated, behave unfairly, this bet is void, refused to pay out. And Mr. Ivey's just saying, that's not the case, I deployed a legitimate advantage and was open about my conduct, and this is what the court has to resolve. And it is the case that under the Gambling Act of 2005, a bet can be declared void if it was substantially unfair, and that's what the court is considering. And among the factors to be considered when it's making this determination is the question of whether the behaviour involved the commission of the offence of cheating, contrary to section 42 of that act, the Gambling Act. Now, the judge at first instance decided that Mr. Ivey was genuinely convinced that what he did was not cheating. So if it had been a criminal case, it would sound like Mr. Ivey has an argument under the second limb of Ghosh, that he didn't think he was doing anything wrong. But notwithstanding the fact that this judge in the civil proceedings thought that Ivey didn't think he was doing anything wrong, the judge went on to conclude that what he did was cheating. And so Ivey appeals and it gets all the way to the Supreme Court. And there the Supreme Court holds that in assessing whether the conduct was cheating, it wasn't necessary to decide whether the behaviour was dishonest. And they went on then to decide that the trial judge's assessment was correct, that there had been cheating and therefore the bet was void. And so that, you would think, was the end of the matter. But notwithstanding the conclusion that dishonesty wasn't relevant in that particular civil proceedings, the court took the opportunity to review the history of the test of dishonesty since the Theft Act 1968, and in particular since the Court of Appeal decision in Ghosh. But because they've already decided that dishonesty is not relevant to assessing Ivey's behaviour, their later examination of the law is of course what we call obiter dicta. It's by the way comments. It's not part of the ratio of the case, not part of the reason for the case being decided the way it was. And ordinarily it's the ratio of the case that's binding as a matter of precedent, and obiter dicta comments normally are not. And so that leads us to the second aspect of the case, which I'll return to later, which is whether this is binding authority from the Supreme Court. But let's go back to the test for dishonesty, because the Supreme Court went there. And in a nutshell, the decision of the Supreme Court removes the second requirement under the Ghosh test, that subjective element that I've mentioned, the need for the defendant to, him or herself, know that what they were doing was dishonest by the standards of ordinary and reasonable people. And more specifically, Lord Hughes, with whom the other members of the court agreed, he disapproved of the decision in Ghosh. In effect, he meant that the court had made a mistake, that they had erred, and in particular, he said this: the several considerations provide convincing grounds for holding that the second leg of the test propounded in Ghosh, that's the subjective one, does not correctly represent the law, and that directions based upon it ought no longer to be given. The test of dishonesty is as set out by Lord Nichols in Royal Brunei Airlines and Tan, 1995 case, and by Lord Hoffman in Barlow Clouds, and that's a 2006 case. When dishonesty is in question, the fact-finding tribunal must first ascertain, and this is subjectively, the actual state of the individual's knowledge or belief as to the facts. So what were the facts as Ivey believed them to be, for example? Not did he think it was dishonest, but what were the facts? So the first thing the court had to determine was, what did he think the facts were? Now, the reasonableness, this is Lord Hughes going on, the reasonableness or otherwise of his belief is a matter of evidence going to whether he held the belief, but it's not an additional requirement that his belief must be reasonable. The question whether it is genuinely held on those facts. When once his actual state of mind as to the knowledge or belief as to facts is established, the question whether his conduct was dishonest is to be determined by the fact finder, that's the jury or the judge or the magistrate, by applying the objective standards of ordinary decent people. There is no requirement that the defendant must appreciate that what he has done is by those standards dishonest. So, determine the facts subjectively as the defendant believed them, then ask whether what he did was dishonest by reason, according to reasonable and honest people. No need to ask whether he knew that it was dishonest according to those standards. And what Lord Hughes did was he identified a number of difficulties with the second limb of Ghosh. And forgive me if I read them all to you. Firstly, he said, is it has the unintended effect that the more warped the defendant's standards of honesty are, the less likely he is to be convicted of dishonest behaviour. Secondly, he said that this objective test was based on the premise that it was necessary in order to give proper effect to the principle that dishonesty, and especially criminal responsibility for it, must depend on the actual state of mind of the defendant, whereas the rule is not necessary to preserve this principle. And if you're ever going to look at this in depth and compare it with other mental elements in crimes, this is probably the one to focus on, but it is quite opaque and needs a little bit of thinking about. Now, the third thing that Lord Hughes says, it is a test which jurors and others often find puzzling and difficult to apply, and from my experience in practice that was definitely the case. Fourthly, he said it has led to an unprincipled divergence between the test for dishonesty in criminal proceedings and the test of the same context when it arises in the context of a civil action. So dishonesty is relevant to criminal proceedings and can be relevant to civil proceedings, and Lord Hughes didn't like the fact that the test in each set of proceedings was a different one, so Ivey aligns the tests. Fifthly, he said the test represented a significant departure from the pre-Theft Act 1968 law, when there is no indication that such a change had been intended. And lastly, he says, moreover, it was not compelled by authority. Although the pre-Ghosh cases were in a state of some entanglement, the better view is that the preponderance of authority favoured the simpler rule that once the defendant's state of knowledge and belief has been established, whether that state of mind was dishonest or not is to be determined by the application of the standards of the ordinary honest person represented in a criminal case by the collective judgment of jurors or magistrates. So there you have it. The Supreme Court have decided that the Court of Appeal made a mistake in Ghosh, a mistake in interpreting the previous cases, and that Parliament in the Theft Act hadn't intended to alter the state of the law before 1968, and the Court of Appeal had made a mistake in its interpretation of the law. And they put forward really this alternative two-stage test, where the first thing you do is say, what does the defendant believe the facts to be? And secondly, based on the subjective knowledge of those facts, not subjective knowledge of honesty, but just the facts, you then ask, was his conduct dishonest by the ordinary standards of decent people? So the standard that's applied for honesty or dishonesty is an objective one. Now that, of course, would have been a problem for Mr. Ivey if he's charged with a criminal offence, because he has an arguable case for suggesting that under the second limb of Ghosh, he didn't think that what he did was dishonest by the standards of reasonable, honest people. But he would have been left with just the objective test had he been charged with an offence, and that would have left him in a difficult position. It would be wrong to say that the test is entirely objective, because there is that little introductory subjective element where the court has to decide the defendant's knowledge or belief on the facts. But it's only once you've got those facts you then apply the objective standard, but it's predominantly an objective test. Now, the Supreme Court gave an example to explain how this test could be applied. And the example they give, which is an example that you might have seen used before is a foreign person arrives in the UK and they believe that public transport is free because that's the case in their home country. So they get on a train, they don't buy a ticket, and they get prosecuted. Now, therefore, let's say they're prosecuted for fraud or something that involves an aspect of dishonesty. When it gets to that element, the jury are going to have to decide whether this person's dishonest. And the first thing they do is say, what were the facts as he believed? And the facts that he believed them was that he thought public transport was free. Now, he's mistaken on the facts, but those are the facts that he believed. And that's the subjective element. You then ask whether reasonable people would think a person in possession of those facts were behaving dishonest. So you don't say, would a British person getting on a train know they had to buy a ticket? You say, a person, this foreign person with the state of their belief, would reasonable people think that that person is dishonest? So you put yourself in their shoes, in effect, with their belief. And the Supreme Court thinks that a jury would think that if a foreign person came in and made that case, that they would decide that that's not dishonest by the standards of honest and reasonable people. So there you go. So overall, we've got the removal of this second limb of the Ghosh test, and it's reduced the ability for a defendant to establish an absence of dishonesty or a presence of honesty, if you like. But if you think about it, it was quite an odd test because it meant the standard for dishonesty changed with the accused's own moral compass. So you had to judge it by his standards in one way, and that's one of the first comments that or criticisms that Lord Hughes made. So it was slightly odd. It'd certainly be easier for juries because it's a simpler test to apply. Once you've decided the facts, they simply ask that question: would reasonable, honest people think the behaviour dishonest? So back to Barton and Booth, because I've left this case largely to one side at the moment, looking at the case of Ivey. So back to Barton and Booth. Here the case provided an opportunity for the Court of Appeal to express an opinion on whether the new Ivey test identified in the civil case actually applied in criminal cases. Now, unusually, I'm going to skip over the facts of Barton and Booth, as it's really about the law, but suffice to say, in that case, the appellants ran a nursing home, a luxury nursing home, and they dishonestly obtained money from the residents. And, for example, one of the appellants sold Rolls-Royce motor cars to the residents at inflated prices, and so it must have been properly a very luxurious nursing home indeed. But the central question in our present case of Barton was whether the correct test for dishonesty in criminal cases was that of Ghosh, because that's what the Court of Appeal said in criminal proceedings, or whether it was that in Ivey, the Supreme Court, in the civil proceedings. And this was still a live issue in Barton because of what I've said about the Supreme Court opinion on dishonesty being strictly obiter dicta. And given it was obiter, it would not normally be binding on the lower court, and the question was therefore whether the Court of Appeal was bound by the statements that were made on this point by the Supreme Court in Ivey. And that brings us to the second aspect of the case. In order to decide what the test for dishonesty is in criminal proceedings, the court had to ask whether the Court of Appeal in Barton, was bound by what the Supreme Court had said in the civil proceedings in Ivey. And the Court of Appeal decided that it was bound by Ivey, as it thought that the Supreme Court had actually changed the rules on precedent during the course of its judgment. And more specifically, this is what the Court of Appeal said in Barton. In Ivey, the Supreme Court altered the established common law approach to precedent in the criminal courts by stating that the test for dishonesty they identified, albeit strictly contained in obiter dicta, should be followed in preference to an otherwise binding authority of the Court of Appeal. So there you have it. They found the position in the Barton case, in terms of assessing precedent, to be strongly analogous to the position in two cases of 2006, the Crown against James and the Crown against Karimi, and they used them to back up those cases to back up this conclusion. If you're interested in that aspect, I'll leave you to explore the detail of that, but I've given you the gist of it and the important change in precedent that was identified there. Because I think for most people viewing the video, it is the test for dishonesty that's going to be the most important aspect of this analysis. So, by way of sort of recapping, in 1968, the court, in 1982, the court, in the case of Ghosh, the Court of Appeal got the law wrong, and it took some 30 years or so to put it right. And for people of my age and experience in the criminal courts, that's a remarkable turnaround, similar only perhaps to the 2003 case of Crown against G on the mens rea of recklessness, which I've also analysed on this website, and also maybe the 2016 case of Crown against Joji, which I'm still putting off analysing here, as to be honest, it is a bit complicated. But this is the end of this particular analysis, and I wish you all well.